I'm going to use that question to confront perhaps the major issue tonight. And that's the question of how do we get rid of John Yoo. I come to this with some of the concerns that Lisa mentioned. I am a First Amendment lawyer. Part of my law practice is representing professors who have been wrongfully denied tenure, terminated, disciplined. I work with the American Association of University Professors that has a strong and robust policy on academic freedom. So I begin from a place of a presumptive protection for academic freedom, and the way I test that is to ask if the shoe were on the other foot and a professor I agreed with were being accused of things, would that professor be entitled to academic freedom and First Amendment protection? However, I have studied the issue as it relates to John Yoo and the specific rules that apply here. I was very disappointed in the public statement that Dean Edley issued defending, or at least refusing, to consider whether or not charges should be brought against John Yoo. Unfortunately, we now can call it the Edley memo because the Edley memo is false and misleading. Dean Edley left the impression with anyone who read the memo that the only type of unacceptable conduct that was relevant to this situation was the commission of a criminal act which has led to conviction in a court of law and which clearly demonstrates unfitness to continue as a member of the faculty, citing Academic Personnel Manual Section 015. Well, I did my homework and I went to Academic Personnel Manual 015 and the General University Policy regarding academic appointees. And what anyone who goes there will find is that the listed and specified types of unacceptable faculty conduct constitute a minimum level of conduct, that these are examples of the types of unacceptable faculty conduct and are not exhaustive. Faculty may be subjected to disciplinary action under this code for any type of conduct which, although not specifically enumerated herein, meets the standard for unacceptable faculty behavior set forth above. And even with respect to what the rules of conduct do specify, it states that faculty misconduct that is either serious in itself or is made serious through its repetition or its consequences. Its consequences. Think of that in the context of everything we talked about tonight. It's a question of whether it significantly impairs the university's central functions as set forth in the preamble, and that other types of serious misconduct, not specifically enumerated herein, may nonetheless be the basis for disciplinary action if they also meet the preceding standards. And in addition to those general provisions, as I believe a faculty member indicated from the floor a few minutes ago, violations of canons of intellectual honesty, research misconduct, and serious violations of university policies governing the professional conduct of faculty, including but not limited to policies applying to research outside professional activities. It seems to me that a fair reading of each of those principles, as well as the general savings clauses, suggests that if you had here a science professor who had engaged in unethical research in their outside activities. And we know that John Yoo began here in 1999, I believe, took his leave of absence, and then returned to the university. I think that's important. He kept his position, he went for outside activity, as many professors do, and then he has returned to this campus. And to the extent that those outside activities qualify for any of the terms that I have quoted so far, as well as any other traditions or examples that may exist in the archives of this university, then I think at a minimum, there are grounds to convene a hearing to examine all of the evidence that we could barely touch on tonight, to have law professors, ethics professors, members of the legal community, to examine this conduct in light of these standards. I myself would not consider classroom teaching. If it is within the scope of his teaching, he frankly can say almost anything in the classroom, because there are too many examples from Ward, Churchill, and others around the country where I would defend to the death classroom teaching, even if I disagreed with it. But we're not talking about that. We're also not talking about writing passive law review articles. We are talking about a government official whose conduct was the advice and the memos he wrote and the consequences of that conduct. I think that clearly opens the door to this kind of investigation. I'm saying this now publicly for the first time because of the analysis that I've put into this in preparation for tonight. I believe that he's entitled, if he won't give it to anybody else, he's entitled to due process, he's entitled to fairness, he's entitled to defend himself, he's entitled to call the best lawyers who will represent him, and one of those, even in the devil's advocacy context, will not be me. And then we are entitled to spread the evidence on the record and allow the system to decide whether this man deserves to be teaching here anymore.